my lord. Welcome back. The judgment which is appealed from is behind tab 8 of the call bundle. You
Yes.
have it separately. It's on page 101 of the call bundle.
Yes.
And I refer to that straight away because it contains, I hope, an accurate list of representation before you today.
Yes.
Having to go through all of that. And I think the plan is, procedurally at least, that we're going to deal with alternative remedy first.
Yes, please.
And then discreetly with the grounds point. My learned friend will open his application notice.
So Sir James, that accords with our plan, as it were, that we'd like to hear the appeal first, completely. We don't know how long you both think that is going to take, but certainly finish by 3 o'clock, and it may be you can finish before then, but certainly by around 3 o'clock, leaving an hour and a quarter or so for the application for permission to appeal by way of cross-appeal.
My lady, yes. I've spoken very helpfully with my learned friend, Mr Hussain, and we anticipate being a bit quicker than that. We
Good.
hope.
That makes sense. Secondly, and discreetly, if it's convenient, just to raise the fact that we received a very short closed note this morning, which we have all read, and our immediate reaction is that we don't really understand why it needs to be closed. So could your side have a think about that, and perhaps get in touch with the special advocates, see whether they have a view on that. But having read it, it's short. It doesn't seem to us that it needs to be enclosed. Maybe we're missing something, but it'd be very helpful if you could just have a look at that and get back to us.
Leave that with him.
Thank you very much. Is there anything else? No. Thank you. Yes, James.
My lords, on that basis, I was proposing simply to pitch in and deal with alternative remedy. And I wanted to start with the Act itself, because that is the key to all of this. But we've dealt with it in our skeleton argument for the purpose of this part of the argument before you today. That skeleton is entitled Appellant's Replacement Skeleton.
You have it?
Page 17 of the call bundle.
Yes.
That's what I'm going to be referring to, and you'll see we've summarised the relevant provisions of the Act between paragraphs 10 and 20 of that skeleton.
Yes.
The Act itself is behind tab 5, if you could take it up, of the authorities bundle.
Yep.
And I'm just going to spin through. I know these will all be very familiar to the court, so I can take this pretty quickly, I think. You'll see the basic structure of the Act. We start at section 3 on page 23. And if you just remind yourselves of subsections 3, 4 and 5 on page 23 of the authorities bundle.
Yep.
Can I just invite you to cast an eye down those? They need, of course, to be read with one, but one is doing the final legal effect thing.
Could you just give us 1 second?
Just give me a moment, Sir James. Thank you. I haven't seen this. Yes. Thank you, Mr. Hussain. I've just received your letter. That absolutely fine. Thank you very much indeed. Yes.
So I was looking at subsections 3, 4 and 5. You'll see that there is a power in the Secretary of State to make an order. The relevant one is 3A, adding an organisation to Schedule 2.
Yes.
And you'll see that the effect of adding something to Schedule 2 is dealt with in sub 1.
Yes.
It means that the organisation is prescribed for the purpose of the consequential provisions of this Act. And then 4, that is the legal precondition to the exercise of that power under 3A, in other words, the adding of an organisation to Schedule 2, only if the Secretary of State believes that it is concerned in terrorism. And concerned in terrorism is then defined in sub 5.
Yep.
Right? That...
The basis here was commission participation and preparation.
Exactly.
And promotion and encouragement? Doesn't matter. I think it was all the first three.
Above. Exactly.
Yes.
Just cut from there, if you would, a few pages further on to show you how that power has to be exercised in terms of democratic accountability. If you go forward to section 1, 2, 3, bearing in mind that you'll remember that in subsection 3 of section 3, the Secretary of State may, by order, and this tells you how orders have to be made. And 1, 2, 3, sub 4 over on page 55 is the relevant one. And you'll see that that's the relevant one because sub 4A refers back to section 3.3. I'm on page 55 now. An order under any of the following provisions shall not be made, subject to sub 5, unless a draft has been laid before and approved by resolution of each House. So that's the affirmative resolution procedure, which you'll be very familiar with. There are some provisions, some orders that can be made by reference to the negative resolution procedure, but this isn't one. If you want to add, you need Parliament's positive imprimatur on it, as you see from 4A. That is, of course, in terms subject to subsection 5, and you'll see that subsection 5 over on page 56 makes specific provision for doing something different, less procedurally onerous, in cases of urgency. I've summarised that fairly. We're not in that territory. But that shows you how it needs to be made. So if you're going to add an organisation to the list, you need that stamp of parliamentary approval. If an order is made, go back to section 3 and flip over to section 4 on page 25, if you would. If an order is made, there's then specific provision made in this primary legislation for deproscription applications and appeals. And deproscription applications are dealt with in section 4. And you'll see from section 4 that there is a right to apply to the Secretary of State for an order removing an organisation from Schedule 2. And you'll remember that was one of the categories in 3.3b, if that makes sense. But you can apply for an order to take yourself off, to take the organisation off. That's sub 1. Note also that the application or an application of that kind, in effect, a review by the Secretary of State in light of all the information that is then available, that can be made both by the organisation that is proscribed and by any person affected by the proscription, see sub 2 of section 4. There is then an empowering provision or an enabling provision, enabling regulations to be made for the purpose of regulating the procedure for those sorts of applications, with a mandatory set of things that have to be covered, set out in sub 4 of section 4.
You just read 4A.
Sorry?
You just read 4.4A.
4.4a, my learned friend wants to draw civic attention to.
Yep.
Yeah, I've got that. I was going to come back to that, but we've got 4.4a. It has to be within a specified period of time. That period of time can be provided for in regulation.
And that is 90 days.
That's 90 days.
Yes.
And if you want it, 90 days comes from Reg 7 of the 2006 regulations that are enabled by those primary legislative provisions. And in the bundle, Reg 7 of the 2006 regs is at tab 9, page 110.
Thank you.
The legislation moved to section 5, then set up a body, a specialist body, which was created for the purpose, as you see from 5.1. It's called the Proscribed Organisations Appeal Commission, POAC. It was, as I say, created in the primary legislation for this very purpose, and its jurisdiction is to determine if the deproscription refusal, if I can call it that, under sub 4 by the Secretary of State is flawed, and its jurisdiction is defined by reference to the principles applicable on an application for judicial review, see sub 3. So anything that you can do by way of judicial review, you can do before POAC, is the point about that.
In relation to a refusal.
In relation to a refusal, yeah. And I will obviously come back to that. It was a point that the judge was interested, if my lord is right.
Is it right that anything can be done? I mean, if it considers that the decision to refuse was flawed when considered in light of the principles applicable on an application for judicial review, you say that the POAC can do anything that could be done on JR?
Well, it's remedially limited, as we will see from the provisions that follow.
Yes.
but in terms of its basic jurisdiction and what grounds of challenge to the lawfulness of the refusal to deprescribe can be mounted, my submission is of, this is a relatively common provision, applying the principles of judicial review, to which one should add, if one's looking at the jurisdiction of this, section 9, if you just keep a finger in section 5, that's because I'm going to come back to the usual side of things, just on the nature and grounds of the challenge. If you go forward to section 9 on page 34, you will see its effect. And what that does, under section 7 of the Human Rights Act, is to designate certain tribunals as appropriate tribunals for determining certain human rights type issues. And the Commission is the designated appropriate tribunal under section 9.
But only for the purposes of dealing with human rights applications in relation to refusals to deprescribe. Is that correct?
Exactly so. Yeah. That's the basic jurisdictional limit. The whole structure of this Act is that the Parliament is contemplating it going first to the Secretary of State, and once the Secretary of State has decided not to deprescribe, if that is the decision, then there is this appellate structure which follows from that challenging that decision. So that is the challengeable decision. And the rules to which section 9 refers, again, you have in the bundle if you need them. You have it in the bundle if you need them at tab 8, page 99. And the effect is that POAC is the appropriate tribunal, is the language of the rules, for complaints that not deproscribing, my Lord's point, is incompatible with convention norms. Go back to section 5, so that's the basic jurisdictional limit. You've got JR principles and you've got incompatibility of the deprescription decision. And then you have remedy involving Parliament again. That's subsection 5 of section 5 on page 26, where an order under sub 4 is made. And that's where it allows an appeal on applying those principles, JR or incompatibility. And then the Secretary of State is required as soon as practicable to lay before Parliament in accordance with 1, 2, 3, 4. And you'll remember that that was the affirmative resolution one. An order removing the organisation from the list. Unless there's urgency, which is 1, 2, 3, 5. Does that make sense?
Yes.
So Parliament gets to look at it again, if that is the decision of POAC, and it, at least in theory, has a say about whether or not some organisation should be removed in the event that POAC so decides. The composition and process that is to be followed by POAC is dealt with in Schedule 3 to the Act. That starts on page 64 of this same tab. And Schedule 3 is to be read with the relevant associated rules that govern the procedures of POAC. And those are to be found behind tab 10 in your bundle, 114, page 114 and following. Just to pick up a couple of bits and pieces from those rules and that schedule. Perhaps the most, or the starting point of interest is in paragraph 4 of Schedule 3, page 67. You've got to have 3 members.
Yes.
One of them has got to be someone holding high judicial office. And then other members
So
appointed to that
three with one holding high judicial office.
Exactly so.
Yep.
So, certainly in my experience, and we see it from the Sri Lankan Tamil case, or cases that are in the bundle that I'll come back to, which you'll see the basic composition of one was Justice Elizabeth Lane in the chair when she was sitting at first instance, there was an upper tribunal judge, and then there was a security specialist, if I can put it that way. So you have that structure, which again is relatively common. SIAC, IPT, not quite the same, but nearly. So it's got to sit as three, one of whom holds high judicial office. The closed nature of the POAC process, or the possibility that it will need to have closed proceedings, is dealt with in some detail by way of empowering provisions in Schedule 3. And you'll see in particular, and just by way of example, paragraph 5.4 on page 69. Again, these are in quite standard form. You can withhold things on national security grounds, or under a duty not to disclose things that would damage the public interest. And you can appoint special advocates and so on. And the themes that Schedule 3 there refers to and there deals with are picked up in, if I can put it this way by way of shorthand, expected ways in the underlying detail of the rules, the procedures that govern POAC. As I say, you find them behind tab 10, and the detailed provision is made for closed proceedings. And again, it's a point I'll come back to, but you will notice, subject to the note that you will think had this morning from the special advocates, but you will recall that the contrast with the Justice and Security Act, for example, is you don't have it's got to be national security in order to go into a closed material process. This is broader. This is damage to the public interest, so it will cover things that might otherwise be covered by PII, such as international relations and/or things that might affect or prejudice a criminal trial. That can be covered and dealt with by POAC in the private or closed section provided for under the primary legislation. Just go back to complete the picture. Once POAC has decided, there is provision in the primary legislation also for further appeals from POAC, essentially to the Court of Appeal on a point of law. See section 6, page 28.
Yes.
And you will see, just if you are on page 28, if you would, just to very briefly, within section 6, you'll see the provision that is specifically made in the primary legislation in 6.3.
Yep.
So Parliament is effectively excusing in the primary legislation the Secretary as an automatic stay, if you will, pending final resolution on an appeal. So you don't get the thing just automatically crossed, subject only to the court's discretionary powers. So, here's a provision of primary legislation that says, no doubt driven by the public interest and the precautionary need for protection. Here's a thing that says you've got to wait until the appeal has been finally resolved. So those are the provisions of the Act I wanted to draw attention to, the Act and the relevant.
You don't want to
Section
draw
7?
attention to 7? Oh, sorry.
Yes, section 7. Sorry, I was going to come back to as a discrete thing, because obviously the judge was interested in that. 7.5, you will note in particular.
Well, 7, I think all of 7 is probably relevant for us. Yeah, we've read it, I think.
Yes.
Yes.
I assumed you would have done. I'm going to come back to that
Yeah, because that's critical.
area of concern for the judge. Turn now, if I may, to the principles that appear from a series of high authorities as to how you approach alternative remedy.
Largely common ground, as far as I can tell.
Largely common ground, but I want to go to some of these authorities very briefly. I know you'll have read
No,
them. I
that's
want to draw
absolutely
attention to a couple of paragraphs. I can do this quickly.
Yes.
But I do it because it's a point of some importance, particularly given the argument that we make, which is when you fairly read the judge's judgment, what he was not doing was to apply this as a judicial review, as it were, as a last resort in circumstances in which the legislation had in fact.
But your complaint is that the learned judge below, carried out a comparative exercise when you say the question of suitable alternative remedy is a standalone question. You look at the alternative remedy being posited and ask yourself, will that do? Is that right?
My lady, yes. And we put it almost as a presumption. There's a strong presumption appearing from the case law we submit that if Parliament has gone out of its way in legislation to provide for appeal rights and has made detailed provision for how that regime should work, it would require an exceptional case before judicial review would cut in and be treated as being a suitable alternative remedy. So this isn't just which remedy we think is by and large and on balance better, or which processes do we think is by and large better. And that is in large part, as we'll see from the authorities, because it is entirely appropriate for the court to accord constitutional respect to the regimes that Parliament has decided, because very often, as here, Parliament would have made a series of judgments about what will and should happen in certain circumstances, Section 6.3 being an example of that.
So do you say it was legitimate for the judge below to carry out a comparative exercise?
My lady, we don't disagree with the exercise, because ultimately you have to look at both of them to see what the features of both are.
I see.
The quibble is not with that as an exercise, it is with the way in which that is then applied and the principles that govern how that should then be applied.
Right.
And we say you give particular weight to the existence and features of the regime that Parliament has decided to set up. And that's the principle I want to go to the authorities for.
And again, just common ground, as I understand it, below and here, that Parliament did not intend to oust judicial review of the decision to prescribe.
Never our case.
Never your case, and that remains your
Remains
position.
the position.
Thank you.
And you'll have seen that referred to in almost the first analytical paragraph in Mr Justice Stephen Richard's judgment in the Kurdistan Workers' Party case. But we certainly don't say that this is an oust, that you require clearer words. I don't need to be plenty of cases telling me that clear words are required if you're going to oust the jurisdiction of a court.
So if it's permissible to, and I know you want to take us to the authority, it's helpful for us to know where you're coming from. If it's permissible to carry out a comparative exercise, in what way is your primary submission that the judge diluted the test? Because he carried it out without giving adequate weight to the fact that Parliament had set up an alternative scheme. Is that it?
It's not just a weight point, because that put to me by an appellate court is to diminish the argument.
Yeah.
It isn't just a weight point, it's a principle point. The authorities make absolutely clear that the prime resort, the resort of the remedy of first resort, is the statutory scheme. And it requires something very exceptional for judicial review to come in and take over, as it were. And what that leads to is if you end up in a position where some of the factors you're looking at are in fact factors which tend to generality because they are features of the statutory scheme, then it's very, very difficult to make the case that that is exceptional.
But the statutory scheme that you've very helpfully taken us to this morning is all a scheme to deal with refusals to deprescribe. Where is the statutory scheme to challenge decisions to prescribe?
Well, my lady, we say that that's in the statutory scheme as well.
Well, that is surely the first and critical question. Is this a scheme where Parliament does require a challenge to a decision to add to the list of prescribed organisations? And what you say is yes, by a two-stage route. Firstly, the individual must apply to deprescribe. Secondly, if there's a refusal to deprescribe, you can appeal against that decision. And the first question is that intended to be the route by which you challenge the first earlier decision?
And my lord, my answer to that, you won't be surprised to hear me say, is yes, plainly.
But if you're wrong, you lose.
Well, if I'm wrong, then it would undermine the scheme in its entirety, because anyone can just turn up and say, I'm challenging the original prescription.
They can within the 3-month period provided by judicial review, yes, not after.
Well, my lord, yes, but the question rhetorically can be posed, why on earth would you do anything else?
But anyway, that is the question.
that's the
So
argument.
your position is that the intended route, the clearly intended route for challenge by persons affected, amongst others, to a decision to prescribe is plainly the POAC route.
Yes.
And anything else would undermine the scheme entirely. That's your position.
It is. And we respectfully submit that was the position that Mr Justice Stephen Richards effectively reached in the Kurdistan Workers' Party case, which was, if anything, more stark than ours, because in that case there were a bunch of remedies sought and a bunch of arguments sought to be mounted, which could not have been, at least naturally, dealt with under that regime, and all required thinking as to whether or not, if you were making challenges that went to the original proscription, some of them were procedural challenges to the original proscription, so it was said they couldn't be raised in relation to deproscription. A starker case than ours, Mr Justice Stephen Richards said, was yes, you could raise all of those in front of POAC, raise all of those in a challenge to the deproscription, because they, as it were, carried forward into the deprescription decision. And so all of those then fed into the statutory regime, so there was no lacuna in jurisdictional terms or in terms of the complaints that could be raised. But my submission is that this is an intended scheme by Parliament, plainly, which puts the Secretary of State into the position of, in effect, reconsidering matters in the light of whatever representations are made, and there are detailed rules in the procedure rules. There are detailed rules about what needs to go into the challenge, and so will have to be considered by the Secretary of State. The intended scheme is that the Secretary of State gets to reconsider, and then you go to the specialist tribunal. But the reason I emphasise that I'm going to the authorities is not to criticise the fact that the judge looked at the features of JR and looked at the features of the statutory regime and how it all works together.
Right.
It is to emphasise that this is last resort when you've done that. I think that the presumption, that's probably inaccurate, but you have the sense of it. Can I spin through them? Siva Subramanian first.
Yes.
Court of Appeal, tab 19 of the authorities bundle. Lords Phillips, Mance and Latham. And Lord Phillips was the Marshal of the Rolls and Lord Mance was the Court of Appeal judge. And the paragraphs I want for present purposes are 46 to 48 on page 338.
Thank you.
Can I invite you to cast an eye? I hope they've been sidelined forward.
Yes, they have been.
Already, but
Yes. So where Parliament has provided the statutory appeal procedure, it would rarely be appropriate to grant permission.
for judicial review, the exceptional case. You see, usually, however, the alternative procedure is more convenient, judicial review is refused. And they apply, look at 48, with particular force in the context of the application of them, because what's been set up by the primary legislation in that context is what they describe in the third line as a coherent statutory scheme governing appeals at all levels short of the House of Lords. And you'll see why that is being done. So in other words, that primary legislation has a particular purpose, a good public interest purpose underpinning it. Sensible scheme forward to the object of access to justice, has the merit of proportionality. And then under F, to permit an applicant to bypass the scheme by pursuing a claim for judicial review for a judge of the admin court is to defeat the object of the exercise. We believe that this should not be permitted unless there are exceptional circumstances. That's Siva Subramanian. Watchtower Bible track next.
Exceptional circumstances in that case are simply because the statutory procedure is less satisfactory. So it's important to understand what they refer to as being meant by exceptional. That
Well, my lady, yes.
it's not something extreme. It's something that may arise because the statutory procedure is less satisfactory.
Yes, but it has to be less satisfactory to create the exceptionality. I totally agree that they appear to be looking at those two things as flip sides of the same coin, but they are emphasising exceptionality and they're emphasising the respect that should be accorded to the fact that Parliament has decided that this is the route to be followed, absent something exceptional, which would render judicial review a process. Watchtower Bible, then, tab 25. Paragraph 19, 19. There they're considering conveniently and effectively. My lady put the same point to me there, but you'll see how they put it. Third sentence of that paragraph after the reference to conveniently and effectively is only in the most exceptional case that is that the court will entertain the decision.
What was the decision? What was the remedy in this case?
In Watchtower.
In Watchtower?
I think it was an appeal to a tribunal.
FTT charity.
Yes, a charity, thank you.
Sorry?
It was FTT Charities was the...
Well, we know in Subramania it was the right of appeal versus
Yes, that was good,
JR,
yes.
so it's head on
Yes.
attacking the same decision. And
Yes.
just so in Watchtower, was
It's going back
the
to head.
alternative remedy addressing the same decision?
Yes, I think so. It was an inquiry into under section 46 of the Charities Act.
Two decisions.
Two decisions.
The reason why I ask is that what's referred to as the principle of adequate alternative remedies covers a variety of situations. The one is where you have a statutory appeal process against the decision in question. The other situation is whether there are other methods available, even though they're not prescribed by statute. There could be an internal complaints procedure. You can sometimes make applications to other bodies, including applications to other courts. And the language that's used in that case, or those cases, is different from the language that's used when you're dealing with an appeal process. And if you're not right on your first point, whether there is a statutory provision for appeal here, then it would be a different set of circumstances. Is an application to deproscribe as convenient and effective as judicial review? So you've got to look at the context in which the words convenient and exceptional are used, which means you've got to identify the decision and the remedy.
My lord, yes, although one may be able to discern something of a difference in the language, because it isn't markedly different, and the same basic points inure. Obviously, if it's a completely different aspect of the thing, and it isn't covered by the statute at all, then you're of course in different territory. But they don't seem to have founded in the case law, at least overtly, on that distinction. And what they tend to do is to take a rather broader approach that says if you set up a statutory scheme, you then look at the jurisdiction and what it can deal with, and what it can't, and you look at the reality of it, and you give effect to the statutory scheme if you can, subject to an exceptional case, which requires JR to pitch in. And you'll see how it's put in paragraph 19. And it's put generally on the basis that you're contesting the decision, so that's the decision which will be challenged in the JR, if JR is your comparator, which it always will be. Can you raise the points that you want to raise by way of challenge? That's why I spent a bit of time on the jurisdictional provisions in the Act. In any event, 19 is what we rely upon for the statement of principle. Then Glencore.
in what's covered.
And the problem in this case was they said one decision, the statutory appeal was effective, the decision was to order an inquiry, but another decision, the production of some documents, the statutory appeal procedure wasn't adequate. So although there's a general principle, you do actually have to look at what they decided.
My Lord, I don't want to disagree with that. Of
Yeah.
course, I accept that. You look at the particular decision that's being challenged and you see how you can get after it. So it could lead to different outcomes.
You just invite us and just
Now then, if I want you to look at 38, can I invite you to do that?
Thank you.
Then section paragraph 39, words did not actually cover or provide an appeal against the production order decision.
Yeah.
And then Glencore tab 26.
Oh, sorry, just to finish that point, my Lord, Lord Justice Lewis draws attention to paragraph 39. Of course, that's right, and it does take one back to the issue that was raised earlier. But there you couldn't do it, so it's hardly surprising that JR might have run in relation to that, because you weren't able to access that appeal route to raise the challenge that you wished to raise. So that left one process JR in the game, effectively. Glencore, I was going to go to, sorry, tab 26.
Yes.
Lady Justice Gloucester and Lords Justices Sales and Singh. And the relevant paragraph for our purposes are 53.
Yep.
This is tax. See from the head note. Perhaps if you pick it up at 54, could I invite you just to cast an eye down 54 through to 58, probably halfway down 58. So he picks up the point about ouster that you put to me earlier at 54.
Yes.
I do submit those paragraphs are important and that they bear out the submission that I put to you earlier. If you look at 55, for example, the language used is jail as a remedy of last resort where no other procedure is suitable to achieve that objective. In other words, that the rule of law is respected. About whether the parliamentary scheme in the primary legislation does allow the rule of law to be respected. Matter of discretion, of course, as they emphasise in 55, and then the second half of it. The court should have regard to the provision which Parliament has made to cater for the usual sort of case in terms of the procedures and remedies which have been established to deal with it. Parliament has made clear by legislation that a particular sort of procedural remedy is in its view appropriate to deal with a standard case. The court should be slow to conclude in its discretion that the public interest is so pressing that it ought to intervene to exercise its judicial review function, along with or instead of that statutory procedure. And he sets out in particular policy reasons why that is so in 56, which you would have picked up. And then comes back to it in 58 long been established at the highest level, where Parliament has provided by statute appeal procedures, as in the taxing statutes, it will only be very rarely courts will allow the collateral process of judicial review to be used to attack an appealable decision. That's Preston per Lord Scarman. In that context, that special circumstances or exceptionality is used. Look at the quote in the brackets, 4 or 5 lines into 58. I accept that the court cannot, in the absence of special circumstances, which is highlighted emphasis in the original. And then Lord Templeman, again in Preston Trenchant, judicial review process should not be allowed to supplant the normal statutory appeal procedure unless the circumstances are exceptional and involve an abuse of power of a serious character. And in 59, Lord Sale says, in my view, Preston provides relevant guidance in the present case.
Yes.
So that's some real interest, I respectfully submit. And then Macaleenan in the Supreme Court is behind tab 38. And the paragraphs I want for this purpose are paragraphs 50 and 51 in the judgment of Lord Sales and Lord Stevens. Perhaps unsurprisingly, given the judgment that you see in Glencore, you see the form and nature of what is said in 50 and 51, page 854.
Could you also refer to 55, please?
Yeah, when they're finished.
Thank you.
Which is interesting for its selection from the passages in Glencore as a general principle. And I do respectfully submit that they bear out this point that I keep banging about, which is this is not just in the scales which one do you prefer. This is pay attention to the statutory scheme. This is the parliamentary decision. You only go to JR if you can't get, in effect, to a just outcome through the statutory process. Exceptionality being used in that context. And you see what is said in paragraph 51, where Parliament has enacted a statutory scheme in respect of certain decisions and appeal will in ordinary circumstances be regarded as suitable alternative remedy in relation to such decisions which ought to be pursued rather than having resort to JR. Otherwise, the use of JR would undermine the regime for challenging decisions which Parliament considers to be appropriate in that class of case. So that is the principle recently done from the Supreme Court.
Well, what is said against you is that it's all about what is meant by certain decisions. The statutory scheme that we've been looking at, it will be said, is not in respect of a decision to prescribe.
Well, my lady, I simply don't accept that. It collapses into a form question, a question which should be a question of substance. And I put it that way because what is really important is the jurisdiction of the specialist tribunal that Parliament has chosen to set up. Can you raise the challenges to the decision which is, as it were, the subject of the particular appeal laws? And it was a point, as I say, that was considered on much starker facts in Kurdistan Workers' Party. But if the answer is that you can challenge, in effect, your prescription, but you have to do it through the route that Parliament has provided for the Secretary of State interposed and reconsidering matters in the first instance, and then deciding to maintain the prescription, if you could maintain the basic challenge to your prescription, your inclusion in Schedule 2, then the correct route, the appropriate route, the route of first resort, is the statutory route. Otherwise, it gets undermined. So, although, of course, legally there is a distinction between a proscription decision, where, for example, as in Kurdistan Workers' Party, you might say there's only a set of JR grounds that would work in relation to that earlier decision, because particular matters weren't taken into account prior to that decision. That was the nature of the argument that was being run in Kurdistan Workers' Party prior to that decision on prescription. But even in that situation, Mr Justice Stephen Richards' EM was, I respectfully submit, correctly decided, no, even if you wanted to make that challenge, you could bring that into the challenge to the refusal to deprescribe.
I know you want to come back to Section 7, but the thrust of your argument really is that the way of challenging the prescription decision is through the reconsideration and the appeal. But if that's the case, why is the remedy removing criminal offences limited to a time from the refusal of the prescription, a deprescription application? Because if Parliament had really intended the deprescription and the appeal route to unravel everything that's gone wrong, in inverted commas, if the order shouldn't have been made in the first place, why doesn't Section 7 remove the criminal offences from that earlier time?
Well, my Lord, we don't have an answer to that from the statutory materials or the legislative materials, but presumably the conception was that the interposition of the Secretary of State reconsidering matters for the purposes of considering deprescription was the moment from which the decision, as it were, was finalised by the Secretary of State.
But if the remedy is meant to unravel the consequences of an unlawful proscription, that's what the statute intended. It's rather odd that it doesn't say so.
Well, my Lord, it does say that it applies from that date on. You might say that's a very odd policy decision for Parliament to take, but there's no doubt that that is the effect of it.
It's not a criticism of the Parliament.
No.
It's working out Parliament intention. And your submission, as I understand it, is that the intention of Parliament was that the challenge to the prescription decision was by this two-stage route. But if the intention was to enable the challenge to the prescription decision by this route, you would expect the remedy to be tied to the date of the prescription order, not the date of the deprescription refusal.
My Lord, you might or you might not, but I'm not sure that the one necessarily disproves the other. You can perfectly contentedly have a challenge at the deprescription stage, which would include challenges that applied to flaws in the original proscription decision making. So that part of it is discrete. That's about can you raise the relevant substantive challenges, even if they're, as it were, directly linked to the proscription rather than the deprescription, because they happen to relate, for example, to failure to take into account relevant considerations at that stage. There's a separate question I entirely accept as to why, as a matter of policy, Parliament then chose to put the Section 7.5 point as running only from the deprescription decision.
Because on this analysis, you're saying Parliament intends people to be convicted of criminal offences when they shouldn't have been, because they shouldn't have made the decision in the first place.
Well, my Lord, I'm not sure it's terribly clear, if one looks at that from a slightly different perspective, I'm not sure it's terribly clear whether the criminal position would alter if a proscription decision were to be quashed. In JR.
In JR, yes, but if it's quashed, it ceases to have effect and it's never had effect.
True, but that doesn't necessarily mean that you don't commit an offence under the relevant primary legislation.
But it will never have been a prescribed organisation as a matter of law.
My Lord, quite so, but the offences are not that. They are encouraging. I mean, there's an argument to be had. We haven't got a resolution of that, but there's an argument to be had about that. But I'm not sure I would be prepared to or could accept that if the original proscription decision were to be quashed, that would necessarily undermine or undercut a conviction beforehand. In other words, before the date on which the Section 7.5
Doesn't that make it even more important to go as quickly as possible then? Not wait 90 days for the Secretary of State to reconsider and then POAC and then in order before Parliament?
Well, my Lord, the difficulty with all of that, of course, is that the moment you get into that territory, my answer to it in policy and in principle is that what people need to understand, and can be taken to understand, is that if a proscription order is made, they must not conduct themselves in a manner that would breach the consequential provisions. They might get a let out if the thing is quashed later. They can see that that applies from the date of deproscription,
Anyway, so,
but otherwise not.
but we do have to, we're talking about Parliament's intention, that's an objective statutory interpretive exercise, looking at the Act as a whole, as to whether or not, as you say, from the face of the legislation, Parliament clearly intended that challenges to prescription decisions were to be dealt with through this route.
My lady, yes, and the core argument there you understand
Yes,
well.
but reading the Act as a whole.
Reading the Act as a whole, it
Yes.
risks undermining is the argument.
Yep.
And the point that is put against me entirely fairly is, well, isn't it a bit odd that if you can bring in all those things as a matter of jurisdiction, that the statutory let out from criminal convictions only applies from the later date, and I accept there's a degree of oddity in that, but the fact of the matter is that that is plainly what Parliament has provided, and if that means that people have to adopt a particularly cautious approach about not conducting themselves in a manner that is criminalised under the later sections of the Act, pending that, because they know they won't get an automatic background, so be it. I'll come back to this, as I say, but there may be unresolved issues in relation to precisely how that would work.
I mean, on a challenge to a refusal to deprescribe, strictly speaking, you wouldn't have to consider the lawfulness or otherwise of the original prescription decision at all, would you?
You wouldn't have to, but you could, is
You
the
could,
reason.
but it would be obiter, wouldn't it?
No, not necessarily. Not if you accept the reasoning of Mr Justice Stephen Richards in Kurdistan Workers' Party. That was precisely the point that was being made. Because they were trying to raise challenges that effectively only applied to the proscription decision and didn't inure into the deproscription decision.
But it must have been a challenge to the refusal to accept the validity of that argument that was the ultimate target.
Yes, but that's how it came in.
Of course, but the direct target is the refusal.
The direct target is a refusal, but that doesn't stop you challenging.
No, it doesn't stop you challenging,
No.
but it doesn't. Yeah, okay.
It means that that is your formal target, but if your substantial complaint is a thing that only affected the proscription decision, you can still raise that when you're challenging.
I think one needs to separate out the grounds from the decision. The decision that is being challenged is the refusal to deprescribe. The reason or the grounds why it's said the refusal is unlawful is you should never have prescribed it in the first place. In other cases, it's we've reformed and we're no longer a threat. But the decision is the refusal. The ground on your case is, well, you shouldn't have done it in the first place.
Yeah.
And they could bring that many, many years after the original decision to prescribe.
Yes, I mean, that.
3 years later, they should go back and say, you should never have done this in the first place. And on your analysis, the Secretary of State's got 90 days to think, oh gosh, should I have done that in 2025? And if she says, oh, I'm not going to change it now, then you can go to POA. If you go for judicial review, you go within 3 months of the original order. That's the logic of your submission.
Yes, but of course, but my substantial point is that there is not a lacuna. If you're bringing a challenge which relates only to the proscription, that is not a discrete thing. It is possible to mount those challenges to the formal decision to not to deproscribe.
Yeah, that's what you're challenging, is the refusal to deprescribe.
My lord, you are. And you're doing it on grounds that relate and relate only, as they did in Kurdistan Workers' Party, to the original decision.
So we've interrupted you enough. Macalinon, any other authorities?
No, that's it on the authorities.
Thank you.
We submit that there are two principles that come out of those authorities, to summarise it. JR is, and has been acknowledged at the highest levels to be, a remedy of last resort. That is so for a series of very good and well-established reasons. It ensures, to plagiarise them from Watchtower and from Macalina and for Cedar Subramanian, it ensures the High Court gives priority to statutory procedures laid down by Parliament, and it therefore respects Parliament's judgment about what procedures are appropriate for particular contexts. It also, as a factor that the courts, perhaps of second-tier importance that the courts have identified, avoids duplication of effort that will be required, and of trying to work out how these various forms of process, JR versus the statutory process, would sit and dovetail together, but without, as it were, creating a situation in which the statutory scheme is in effect rendered a dead letter because you can always go after the original decision. And that is always enough. Then because you say, exactly the debate we've been having, well, the original decision only comes into the deprescription decision by a side wind. That's the first principle anyway, last resort. The second principle is that if therefore a claimant invites the court to exercise its discretion to entertain an application for JR, in circumstances where Parliament has itself provided a statutory process and an appeal intended to cater for the substantive challenges that could be made to the thing that affects the individual, then it is for the claimant to show an exceptional case. It will rarely be appropriate to take the wording from Siva Subramanian for that to happen. From Glencore, para 55, the court should be slow to conclude in its discretion that the public interest is so pressing, again their wording, that the court ought to intervene to exercise its JR function, instead of, or perhaps alongside, the statutory process. And it is a constitutionally powerful point, we submit, that Parliament's judgment is to be respected. The risk, per Lord Dyson and per the various law lords in Preston, is of undermining the will of Parliament and its judgment that a particular regime set up in a particular way with particular consequences should be followed unless there is some truly exceptional reason not to do so. And the submission applying those principles is that having regard to the statutory regime set up by Parliament in Part 2 of the Terrorism Act 2000, and indeed the legislative policy behind it, with all the protection of the public interests that are engaged, my submission is that that is an appropriate, convenient, coherent statutory regime, and there is nothing in JR to displace that. Parliament has made explicit and very detailed provision for how challenges to prescription are to be appropriately dealt with in primary legislation and in the enabling provisions to make the various rules and subordinate legislation that sits underneath it. And it's that that should be the remedy of first resort. As Mr Justice Richards concluded in KWP, I'll just give you the paragraph. It's behind tab 17 if you want it. Paragraph 75 of KWP. It is plain, said Mr Justice Richards, in relation to our regime, it is plain that Parliament, although not seeking to exclude the possibility of JR, intended POAC to be the forum of first resort for the determination of claims relating to the lawfulness of the prescription under the TA 2000. Just before coming back to the Kurdish Workers' Party to highlight a couple of features, and I'm going to come to the factors that were considered by Mr Justice Chamberlain specifically, just to highlight 2 or 3 features of this regime. The first of them is that it's a carefully constructed scheme in primary legislation with considerable detail. It's coherent and calibrated, it places protection of the public at its heart. It's evident that Parliament specifically considered, because it made express provision, what effects should occur at various stages. In other words, after the Secretary of State made the original proscription decision, after an unsuccessful challenge to persuade the Secretary of State to deproscribe, and then whilst POAC was considering matters and on appeal. You'll remember section 6.3. What they may be said to require is, in effect, to make sure that those who are affected take a cautionary approach from the moment the order is made in the first place to ensure that they don't trespass into the criminal sphere by doing any of the things that are prohibited from that moment by the primary legislation. That's the decision that Parliament has made, and it's for it to decide when and if so in what circumstances there should be a mandatory removal of those consequences, and it's done that. But fundamentally, the legislation provides access to an independent body or court to protect the various rights that might be affected. It's done so applying the principles of judicial review, and it's specifically extended that to enable convention compatibility challenges of the kind that are central here to be run before the statutory body. There is no part of the challenges that can be made and that are being mounted here that could not be run before POAC. The jurisdictions are coincident. The second point is that under that primary legislative scheme, there are constitutional balances in which the Secretary of State, the Specialist Tribunal and Parliament all have roles. Parliament, as you will recall, is involved at the beginning, affirmative resolution before you even make an order, and at the end, subject to urgency. It's required affirmative resolution at the very beginning before the organisation is added to the list. And it wants to reconsider matters through that same mechanism at the end if there is an end. And that involvement of Parliament is key to the scheme and should lead to the most considerable caution before it's displaced by JR. Because if you go through that JR door, you don't have those features. You remove section 6.3, you remove Parliament's involvement at the end, you alter in significant ways the balance that Parliament has chosen to set up in primary legislation.
So, James, does that mean that in the case of a decision by POAC that somebody should have been deproscribed, Parliament could disagree with POAC in theory and decline to make an order giving effect to its decision?
My Lord, I'm afraid the short answer to that is yes.
So how what's the equivalent position in relation to judicial review if the court strikes it down as something that should never have been made in the first place?
Then you wouldn't have that possibility open.
Parliament can't disagree with the court.
Parliament couldn't disagree with the court in that respect. It would have the automatic effect. Now, you may say it's a thoroughly good thing in terms of rule of law, but with respect, that's something that Parliament has thought about. Of course, it would still be answerable on the international plane to Strasbourg if the basis for that conclusion was incompatibility with human rights. It would still have to answer in that court, not as a matter of domestic law. So in that way, the rule of law is respected because, for the moment at least, the ECHR applies here and the route to Strasbourg is open. But well, it's a perfectly fair question, but you see how we put it. The other side will no doubt say that's a better way of protecting the rule of law, but we respectfully suspect that that's something that Parliament has thought about. And it at least wants to have the opportunity to have a think about that. I mean, in practical terms, one would hope it would be vanishingly unlikely, because they would be likely to respect the courts. But that's the formal position.
Thank you.
So Parliament is involved. POAC is involved. I'll come back to it, but it is the bespoke body considered by Parliament in the primary legislation to be the body suitable to determine these challenges, including the appropriate body, the language from the subordinate legislation under the Human Rights Act, for human rights-based challenges based on incompatibility of the kind that we have here. And the role of the third constitutional actor, as it were, the role of the Secretary of State, is central to Parliament's conception of the operation of the scheme and its procedures. Application is required to be made in the first instance under the legislation to the Secretary of State for deproscription in accordance with the rules that the Secretary of State was required by Parliament to make to govern that process. And those rules are the 2006 Proscribed Organisations Application for Deproscription Regulations of 2006, enabled under section 4.3 of the primary. The Secretary of State is then required to consider that application, take such expert advice as is necessary for her to reach a fully informed decision on the matters raised on behalf of the organisation, take a decision on it, take specialist advice if she needs to, and it's only then, if the Secretary of State rejects the application for deprescription, that there is a right of appeal to POAC, as we've seen. But that is the key first step in the process established by Parliament. And if JR is used, as it were, routinely, if JR is said to be preferable because there is no specific, as it were, right to go to POAC from the original proscription decision, that is a general point. And if that is a general point, it undermines the regime, I submit. Involving the Secretary of State in that way is, we think, a perfectly legitimate and sensible thing for Parliament to have done. It enables and requires that the Secretary of State should think again in the light of whatever representations are made. And one of the mandatory things that the procedure rules have to cover, you'll remember from 4.3, I think it was 4.3, is that the person should have to state what their grounds are for deprescription. The Secretary of State has to reconsider that. And that's particularly appropriate given the institutional and constitutional competence that the executive has in the first instance for matters relating to the protection of the public and national security. But that's what Parliament has done. You've got to go back. You've got to make your case to the Secretary of State, and the Secretary of State has got to decide that. And it's evidently deliberate. Parliament could have created a scheme requiring judicial permission at the outset. Could have done that. That's what it did, for example, you probably all come across TPIMs. That's what it did in the TPIM regime. Section 6.3 of the TPIM Act 2011 ensures judicial oversight at the very beginning, if only to make sure that a High Court judge is satisfied that the decision is not obviously flawed. So the Parliament knows full well how to do that if it wants that model, and it hasn't done that. Instead of that, it has said specifically, you've got to go back to the Secretary of State, it's then that decision that can be the subject of an appeal. And as I say, I do emphasise the point, which is that if the position is that you say, well, JR must be appropriate because there isn't a specific right under the Act to go at the original proscription decision, that's a point of generality. Why wouldn't that always be the position? At which stage you would, as in this case, never get to the deepest mechanism that Parliament has considered to be essential. Third point to emphasise is in relation to POAC's jurisdiction and particular expertise in bespoke processes. Three short points under that heading. Firstly, each of the substantive matters raised here are plainly capable of consideration through the POAC route. Indeed, the substantive points raised by the claimants here reflect the bread and butter of POAC's work, including the convention compatibility challenge. It's got the JR principles it's got to apply. It is the appropriate tribunal for the HRA. Unlike, as I emphasise, and even there it didn't help them, but unlike the situation in Kurdish workers' party, in that case, the position here is that everything can be raised and there's no suggestion to the contrary. That's the first point. Second point is that Parliament has provided, through the primary legislation again, for the constitution of the body, which it considers appropriate to consider appeals, i.e. challenges to the continuing proscription of an organisation. You looked at Schedule 3 earlier. It requires the thing to be heard by 3 members, one of whom has got to have held high judicial office. But the other 2 can be appointed as members, and as we know, routinely it can comprises either another judicial member or a civil court, and or someone involved in the security world providing their specialist expertise. That is the statutory process, and it isn't the same as a JR. In the JR and the admin court, you'll get a divisional court, or you'll get a penal judge sitting in the administrative court. It is not the statutory process. And thirdly, Parliament has also ensured that in every POAC case, POAC enjoys the ability to consider closed material broadly defined, if I can put it that way, without separate application, contrasting with the CMPs available under the Justice and Security Act 2013. So POAC can consider the full range of material potentially protected from disclosure, and a wider range of material potentially at least than is or would be available to the court. Material is protected from disclosure on the grounds of public interest, but POAC can consider it. That is not the same as the national security limitation on the Justice and Security Act 2013. So if and to the extent that there is other material which is relevant, that would bear on that. That includes, not as I say, entirely except in this case, international relations material in an appropriate case, but it also includes, for example, material that might prejudice a future criminal prosecution. It is possible, no doubt, to provide some forms of protection for that, a restriction order, but it isn't the same. In this way, therefore, Parliament has set up POAC as a body that can receive without more and without complication the entirety of all relevant material. And that is a real advantage. You don't have to jump through the various hoops that a JR court would have to do. And we do note, and you'll recall perhaps from the reading of the Kurdish Workers' Party case, Mr Justice Richards, I think those were in the days pre-Al-Rawi, in which Justice Richards thought, well, you may be able to invent a closed material process in advance of the 2013 Act. As it turned out, that was a little optimistic from Al-Rawi, and that's why the Justice and Security Act came in. But my point is a broader one. Doesn't terribly matter. He saw advantage, even if you could, as he put it in paragraph 76, devise something equivalent. He thought there was real advantage in having that clarity and that breadth in relation to what the statute permits POAC to look at. So those are features of the regime that emphasise that this is not merely a coherent and sensible, but a special regime that Parliament has considered appropriate. And all of that, on the order of the judge, gets swept away. Kurdish Workers' Party I keep referring to. I don't know, has the court had a chance to have a look at that? I
Yes.
take that a bit as read.
But is there a particular,
Well,
just
I
give
was
us the
going to
paragraph.
just highlight a couple of bits, maybe,
Yes,
if I can.
please.
Behind tab 17,
Yes,
page 266.
yes.
It might be thought that the court was particularly well assisted. I'd like to pray and aid the distinguished nature of the council appearing before it.
Yep.
You see it, 266.
Yep.
Some of whom at least have gone on to greater things. 286 is where it really starts. Paragraph 70 onwards. And I'm not going to trouble you now, but you'll see the reasoning between there and the end of the judgment gives you a flavour of it. But you'll see what he does in the judgment is to acknowledge the no ouster points, see para 71. And he takes the point that there's no ouster, but what that does is to put up the question, what is the right approach in principle when you're considering alternative remedy? And Mr Sales, as you see in 72, referred them to various authorities. We now have more and clearer. And the forum of first resort line that I referred to earlier is taken from paragraph 75. See the first sentence.
Yep.
And he then goes through the features of the various features of the Act, in effect the features that we centrally rely on, and concludes, in effect, that it would require something pretty special to take one out of that run.
How does the designation under the Human Rights Act apply here? It's not the appropriate tribunal for the challenge to the decision to proscribe, to the order that the Secretary of State made in July. Under the Human Rights Act, it's got to be, a challenge has to be brought in the appropriate tribunal to allege that it's a breach of Section 6. And it's not the appropriate tribunal for challenges to the original decision.
Well, I suspect that the answer he would give to that, I think it was a point that he specifically addresses, or needed to address perhaps, because the only challenge you see from the remainder of the judgment that he was considering in relation to the proscription application was a challenge on standard JR procedural grounds that relevant things hadn't been taken into account at that stage. And his answer to that was, yes, but you can effectively take them over into the deprescription part of it. But I suspect if the point had been put to him, he would have said, yes, but you can raise the substance of all of those challenges, because they will almost by definition continue for as long as you can continue on you, the organisation, or you, the person affected, are continually affected because the organisation remains in Schedule 2. So the substance of all of those arguments can be raised and made and ruled upon without the need to worry about that.
Is this the point that the judge below picked up at paragraph 58 of his judgment? Your point.
Focused on paragraph. Same point, yes.
I think that's the point that the judge picked up on.
Yeah, I hadn't focused on that here.
It's 664.
I think you're effectively inviting us to say, actually, that there is no appropriate tribunal. Nobody can challenge the decision to prescribe at all, and on human rights grounds or indeed any other grounds. And the only thing that can be done is to treat the fact you shouldn't have made it in the first place as a ground for making an application to deprescribe, and then you appeal that decision. It's almost like an implied ouster clause, the way it's being put. Although you say it's not an ouster clause.
Well, my lord, I'm not sure I need to go as far as to do that. My answer to these paragraphs and this point is that if you get to the stage where you are operating the statutory regime, you are by definition in a place in which you remain on Schedule 2 as the organisation because the deprescription has been refused. And so you're thinking about a challenge at that point. And the answer at that point is that you can raise convention challenges. So there's no deficit there.
So the only deficit is in the timing point. It takes the Secretary of State 90 days.
Exactly.
And if she refuses, the decision of POAC is only from the date
Exactly,
of
which is
refusal.
an inherent feature of
And
the
you
statutory
say that Parliament intended people to be convicted of criminal offences even though they should never have been prescribed in the first place. You say that's what Parliament's decided.
Well, my lord, you put it contentiously, but...
Oh, I didn't mean to. I thought I was describing the state of affairs.
But there's an open question about that. But the 90 days is, within 90 days is a feature of the statutory regime. But I submit that the answer to this point is that if you operate the statutory regime, true it is that that will come at a later point. But it comes at a later point, that's because that's what Parliament has provided for. It will come at a later point if the rules underlying this said the Secretary of State has to make a decision within 48 hours. You still come at a later point. The point would still be good in principle. The rest of it is practicality. Just to go back to Mr Justice Richard's judgment, you'll see what para 79, 6 lines in, I recognise that POAC's appellate jurisdiction relates not to the original prescription but to a refusal to deprescribe, whereas by these proceedings the claimants challenge the original decision to prescribe. But in relation to these substantive issues, at least I don't think that anything turns on that point. And that's because they, in effect, could be raised as part of the challenge to a deproscription decision. And he picks up the difference between remedies at paragraph 85 and then deals with a separate difference that was raised in that case, but not in our section 4 of the Human Rights Act in 86. It's clear from 79 onwards that the JR claim in KWP in fact ranged more broadly than the grounds advanced here. It included grounds common to those here, namely, and for example, the original prescription decision was unlawful on procedural as well as substantive grounds, which POAC was capable of considering, including Mr Justice Richards, 79 and 82. And the same points about POAC having no power to quash the original decision or order that Honourable Justice Edis raised with me, dealt with paragraph 85. Yet, despite all of those things, Mr Justice Richards, we submit, correctly considered that it would be inappropriate to allow those points to continue on a parallel JR track, or in effect in substitution for POAC. And we submit that that was a correct decision. So that decision we submit is of assistance and directly in point.
Thank you.
Can I come briefly then to the Mr Justice Chamberlain factors?
Yes.
Timing, we dealt with that in our skeleton of paragraph 35, it's dealt with in his judgment at 34 to 36. I wanted to make 3 basic points about that, in short. No doubt there are, first one is that no doubt there are processes built into the statutory regime that are to be followed with timing consequences. And it may well be that a JR can proceed super expeditiously so as to avoid that. But that, we submit, is simply a feature of the statutory regime. And if it worked, would always justify turning JR into a remedy of first resort. Because the requirement to go back to the Secretary of State in the manner set out in the legislation is a requirement of the legislation. Second point is the introduction of that feature, Secretary of State deprescription, then appeal from that decision, is evidently deliberate. It's express. And there's good constitutional reason for preferring that course, for all the reasons I've gone through, we submit. Certainly a course which is coherent and convenient and sensible and open to Parliament to decide. Thirdly, at a practical level, there isn't any proper basis for the conclusions or predictions on timing that the judge made. If there are features to justify speed of the kind that he identified, they would apply equally in the context of POAC, if the statutory regime is operated, and POAC has more than enough power to direct speed if it wishes to. There's no deficit in terms of power. It can do what the admin court could do by way of expedition, orders and so on. So it really funnels down to the fact that the Secretary of State is involved and has, under the current rules, to make a decision within 90 days. But I do emphasise that that is a long stop provision, as it were. It's within 90 days. You can't predict how long the Secretary of State might need, because that depends, of course, on what is raised, and no one has troubled to go down that route. And the Secretary of State would, of course, need to consider matters very carefully. But she would not be doing so from a standing start. And I emphasise that 90 days is a statutory limit, not a statutory required period, and that, of course, could itself be policed if necessary. But my submission is that to the extent that some period of delay is inevitably built in by that process, that is a deliberate and express feature of the statutory regime. And of course, lots of points in relation to timing remain in the hands of claimants. For the Secretary of State to decide how long she needs to deal with that, but they can appeal to power from the moment they get the decision. They can do that the day after. They can make applications to power to speed the process on if that's considered appropriate. So we respectfully submit that in relation to timing, it's extremely difficult to start comparing and contrasting, acknowledging as we do that JR of a proscription decision can, of course, happen, if it does happen, in advance of and so as to cut out, in effect, a step that Parliament has deliberately provided for, namely the Secretary of State reconsideration. But beyond that, it's very difficult to go very far. So far as detriment to the claimants are concerned, that's dealt with in our skeleton 36 to 41, in the judgment at paragraphs 37 to 43. And again, 3 points on that, if I may. Firstly, those who run and support a prescribed organisation will be subject to the effects laid down in the primary legislation. That is no doubt to their detriment in one sense, but that is what is specifically provided for in the primary. It's a detriment that is inherent in proscription and thus in the statutory scheme. Parliament has thought about the consequences it wants to create. So again, it tends to the general and turns the regime that Parliament has set up back in on itself to provide the justification that will always or very often apply to justify a JR. Secondly, we submit this point about detriment is again at base really about timing in the context of an alternative remedy argument. The detriment applies in effect until the resolution of the challenge by whatever route. And I've dealt with the points on timing. Third point is that we do not accept that detriment can properly be played in aid as extending to those who are engaged in lawful process. Lawful process can, and protest can continue to occur. The prohibited activities are and are only those that Parliament has laid down expressly. And that detriment applies because Parliament has said it should apply. That exposure to criminal offence applies because Parliament has said it should be an exposure. And can I just invite you very briefly to go to Aramugam. There are 2 Aramugam decisions in the bundle of authorities, and I want the one behind tab 30,
Yeah.
page 623,
Yes.
and I want paragraph 117. This is the one with Mr Justice Elizabeth Lane, Mr Whitton QC, and Mr Philip Nelson, CNG. That shows you the composition of the tribunal at the time of and the varied expertise that I was turning on. 117 at 623.
Yep.
She accepted, comes on to accept the submission that the prescription of the LTT does not have any legal effect on the peaceful activities of the appellants and of their organisation. And moreover, and linked to that point, concerns that have been raised about the police operating with a heavy hand that you've seen reference to in some cases, again, cannot justify preferring JR over a statutory process that is clearly set out, essentially for the reasons set out in the second of the Aramugam decisions, which is behind tab 40, 40 in the authorities bundle. decision. Paragraph I want is on page 918. 165. It's really the second half of that paragraph. Do you see about 8 or 9 lines down, there's a line which starts as concluding that they crossed the line. And there's a sentence that starts, all of these things having been said. Reading at the end of the paragraph. And of course it probably doesn't need saying, but it is not permissible, we respectfully submit, to rely on the interests of or detriment to those who seek to pursue as a deliberate tactic, in effect, a set of actions that are designed to engulf the criminal courts. The effects we submit and the consequences of various decisions and actions are prescribed by Parliament, and for as long as prescription is in place, they must be obeyed. And that includes, under the statutory scheme, whilst appeals are proceeding, section 60, as you see. Criminal cases, areas, or the third of the areas, skeleton powers 42 to 45, judgment powers 44 to 49. The position here is that prosecutions under the Act would not be for contravening a bylaw, as in Boddington, contravening the subordinate legislation. The prosecutions would be for offences that are set up under the primary legislation and continue to be offences under the primary legislation for as long as the prescription.
What is said against you is that there's nothing in Boddington to suggest that the reasoning there is limited to secondary legislation. What's the analysis as a matter of principle for it being different in relation to primary legislation?
But it is primary legislation. The courts can't start striking down primary legislation.
No, but it's the order. The only reason why the legislation applies is because the order says this is a prescribed organisation. If you strike down the order, you're not committing a criminal offence, or if in fact the order shouldn't have been.
Well, there's a question about that. Again, we touched on it earlier on. It's a question of, there's a question, I'm not sure it's quite as simple as that, or it may not be. But it depends on how the offences are set up and what.
Well, yeah, I was just looking at them again, but it's critical actually, I think. The wording may be critical in the Act.
Yeah. We want to go back to the Act for that purpose. My submission is it's at least a question as to whether or not you would continue to commit a criminal offence, or if you've been convicted of a criminal offence when the prescription order was in fact in place, irrespective of whether it's later quashed and maybe treated or maybe not be treated under jail principles of void ab initio.
But take the position, say that you're right and we go down the route of application for prescription, 90 days and refusal. There may well be individuals who've been convicted who will want to say, I should not have been convicted because the order adding this organisation was unlawful. And can they do that in the magistrate's court in the period between conviction and the deprescription refusal?
Well, my submission is that it's very difficult to see how they could run that argument in the magistrates' courts in that way.
Very difficult or impossible?
Well, we submit that the Boddington principle would not apply. That's the case we mount in the skeleton argument. There may be, we've raised as a possibility, there may be a possibility for the Court of Appeal to intervene at some later stage, but the fundamental answer to all of this, we go back to the policy of Parliament and why it was set up in this way, but that it was set up in this way is clear. They get the mandatory shutdown of the conviction, if you will, under 7.5, but only from the date of the deproscription decision. They don't get it before then.
And that's the system, and everybody knows that. And if it's like Wicks, you would say, where you've got a planning
You have to operate on a precautionary basis.
Yes, and you've got to say, well, I've got the offence is doing something that's in the planning thing or prohibited by the planning thing. You say it's the same here. Parliament has said, look, this is national security or public interest, so it's an offence. If you want to get out of that, you apply to deprescribe, and there's a process, but beware, you will only be able to get out of it from the date of the deprescription.
Well, you'd only be able to get out of it mandatorily from the date of the deprescription.
Yeah.
And it continues to have effects because the Secretary of State can't be required to do anything remedially by POAC unless and until the appellate routes, onwards appellate routes, are exhausted. You'll remember section 6.3. So Parliament has been tough, it can fairly be said, in a variety of different ways. There is, in effect, a preclusion on a stay, a statutory preclusion on a stay, even if POAC decides against the Secretary of State pending an appeal. But our fundamental answer to this is that these are choices for Parliament to make, and Parliament has set up the regime with the automatic cutout from a certain date only. Now, as I say, you know, there may be a possibility, there are arguments around, there may be a possibility of the Court of Criminal Division intervening in a different way later, but our fundamental point is that Parliament has made these judgments. And what that means is that people have got to be cautious. And if they're not going to challenge, and of course it's open to anyone who's thinking about committing what might be a criminal offence themselves to apply to POAC. You'll remember the people who can apply to POAC from the primary legislation. But otherwise, they have to abide by the regime that Parliament has set up, is our short answer to this. And again, you know, no one's suggesting that these policy judgments are easy or that there's a clear and obvious answer to what happens to the people who might be convicted for conduct in the meantime. I fully accept my Lord's points in relation to that.
So the offence is actually engage in activity in a period before prescription has been, that is actually the offence, and we shouldn't, you said it was pejorative, I thought it was descriptive, but you say that's the offence, actually, to do things in the period before you know that it's not being deprescribed, yes.
Yeah. And again, it's not a complete answer to say this is all about public protection, it's national security and so on, because they have provided for the mandatory quashing of the conviction from a certain date. But as I say, looking at the legislation...
And the portion of conviction for activities after a certain
yes,
date.
for activity.
That's more accurate.
Yes. I entirely agree with that. Anyway, that's what we say about the criminal side. It's essentially a deliberate decision by Parliament, evident on the face of legislation. That means that people have to be super cautious if they're not going to go down the route that is available, even for that purpose. I thought if you're thinking about committing a criminal offence or something that might be, you might be well advised to start giving an application into POAC, or at least asking the Secretary of State to make a decision on deprescription, because that's the coverage that's there. But
and are there statutory, common law principles of statutory interpretation says you don't interpret legislation if at all possible to avoid a criminal offence?
well, you require, of course, there's a principle of statutory interpretation that says if you're interpreting criminal provisions, they have to be clear. But my respectful submission is that there's nothing unclear or to be interpreted about the provision that says you only get the automatic quashing, as it were, from a certain date. That's on the face of the legislation. And there is a route for creating that. You ask the Secretary of State to make a decision. Forum and procedure, can I just deal with that briefly? Our skeleton argument, paragraph 46, for judgment, paragraph 50 to 59, a collection of points about forum and procedure. Ouster, first of all, we submit that the right approach is the one that Mr Justice Richards acknowledged. JR is not ousted. One can contrast the only provision in relation to SIAC, as he did at paragraph 71, you'll remember that from his judgment. But he didn't consider the point to be legally relevant or significant at all. Correctly, we submit. We've never made an ouster submission. It's clear that it's not ousted, but the principles nevertheless apply. What you don't do is to take into account the fact that it isn't ousted as it were, a factor in favour of JR applying. All it does is to tee up the question.
So if you're, well, you say it's not an ousted situation. If one adopts your analysis and your submissions, in what circumstances could one JR a prescription decision?
Well, I suppose one wouldn't close the door on some wholly exceptional case. The example given in the cases are if it's entirely evident that there has been a serious abuse of process that needs to be immediately corrected, as it were.
What the strength of the merits?
Well, it wouldn't necessarily strengthen the merits, or if it's evident that the Secretary of State has exercised the power for wholly incorrect reason.
So it is the strength of the case.
Well, that would have to be a relevant factor, or the grounds on which it's made, or some other reason for concluding that the statutory process was evidently not appropriate.
And there are some dicta in the authorities you took us to about the court considering whether there has been a particularly egregious abuse by the Secretary of State, but that means you entertain the challenge and assess the gravity of what is alleged and what you have found, and then decide, perhaps, I think in one of the authorities, what remedy, if any, you should follow, because you could deny a remedy.
My Lord, you are inevitably sucked into that territory to a degree.
But that means it's not a bar to the court considering judicial review necessarily.
Certainly not.
It means the scope of the judicial review might be narrowed so that the court would only grant a remedy in a bad case.
Well, my Lord, that possibility must exist if it isn't an ouster.
Yes.
The reason I was about to interrupt, my Lord, I'm sorry for that. The reason I was about to do that was to emphasise that isn't an uncommon thing. And of course you get into the territory of the merits and looking at the merits, and so the door is open. But the door is open the moment you don't oust. What the authorities appear to be driving at is where something is evident, clear and egregious, as it were. Something that requires JR to step in, because the facts, for whatever reason, merits or otherwise, render the following of the statutory regime inappropriate. The difficulty, of course, you've got here is that most of the arguments that are being made are arguments of generality. They're arguments that have force if they have force, because the legislation exists in the form it does. It requires you to go to the Secretary of State. It requires the appeal to be from the deprescription decision. It creates criminal offences that operate in the way that we were discussing. And that, as it were, that's what I meant when I said these arguments turn the legislative regime back in on itself to make it feed on itself. And that, we respectfully submit, cannot be the right approach. That's why I emphasised Lord Sales's judgment in Glencore about looking at the usual run of cases. That's what they mean by exceptionality. And if the usual run of cases under the statutory regime are cases to which the statutory regime applies, that will be a usual case by definition. So although, of course, you can get sucked into it, you may have to, because it's not ousted, you need to be very, very cautious about doing it. And on any view, the right approach is not simply to stand back and say, well, look at this, look at that, look at the other. That's a feature of the statutory regime, much like that, balance it all up and reach the suitable one. It's a much more rigorous approach than that, with a much stronger or higher hurdle that the defendant has to overcome, is my submission. My Lord, Mr. Hussain was concerned. Would you mind if he could either be excused?
Of course. Well, should we have a quick? We're doing. I think we've got one more factor
I'm
left.
very nearly done.
Let's have a quick break. 10 minutes. Is that all right, Mr. Hussain? Very good. Thank you.
The problem is once you set it up. Quite hard to really see it. Like just 1 week to do that.
Both of them. They're on their way.
Relate to events post. This is explaining about 9 and 10. It's all about what's going on today.
So what have you
Not actually about
just added the numbers to my
the vision of the
Yes, I've got the
these are this doesn't fit
the rest of me. It's on my master tasting. Yes, I've not touched this.
the section 7.
you written in the new
I just don't think it
no,
helps
not on
either way, because it's a
because I will want to
it'll be better if on the date you make your application, you're protected. The Parliament has said it's not that date, it's the date on which it's decided. How that necessarily helps you decide out between JR and TOA. Yeah, it doesn't carry back or whenever.
yeah, otherwise I just switch it up. Yeah, no. We're now not missing anything. We're now not. We're not missing anything.
And actually, the only way to do it is
It's just the pagination that's out now that we have.
that's the way it's set up. It's just a moment. Yeah.
So what's going to make one with the correct pagination? That doesn't help you very much.
Yeah.
So I'll
Yeah.
I'm going to have a word. Tell me.
would it be handy for one of you to
But isn't it a difference? And secondly, what did you say about second exam?
yes, they will. And if it's all the way through, just like +4, it should get. You don't have to like.
Yeah. Which kind of encouraging me. I agree. I think yeah.
And I'm going to have to try and deal with it in
No,
this way.
they've set it up so that the only mechanism to get to it is through the thing. But as soon as you separate those two like conceptual stuff, then the trigger shuts down. Yeah.
Or if you have, if you just put it in a bracket.
Yeah, yeah.
The only
Yeah.
Your public challenges that you might bring to the original case against the ultimate are actually just focused
you're the Home Office.
on the law and the actual merits of the decision. So that's, but he says it doesn't have to. I just think
I looked at the same thing and decided that most of the couldn't quite do the distinction.
well, also in the Glencore stuff, you may actually not end up with a second decision. During that review, agency may decide not to do anything at all. So then you are effectively appealing against the first decision. Whereas here, you always end up
Well, if I went through the same is it enough? And
I
decide?
think,
Yeah. No,
I did one.
Investing.
266. That's so weird.
Yeah. That's right. And there are lots of odd features about it. Yeah. Going back to Parliament, you know, the Edis question, well, can Parliament defy and not? Yes. Can that recognise Supreme's next.
That's the point was.
Yeah. I assume that's why you were doing throughout. Lining it for that. Just pointing
Can
out.
I just move across? Because we're not going to be on until. Sorry about that.
We wouldn't be able to spend the JR, can we?
If they were to be the first thing forward.
I think we might have to accept the thing went ahead. We are willing to go
But no,
quickly,
absolutely.
but we might have to accept it. Even if the JR proceeded, we would nevertheless want it resolved in the future.
Can you give cards?
You want to give copies of that?
Yeah.
Well, only do that.
What is that? Card? I've got cards.
Yeah. Yeah.
I don't need one. I have my own card.
No, I do.
You make all you do before I give them all away.
Well, that would be the next. That's when there's. Very careful.
The tab's corrected.
Had it in the low.
So far in mind.
James got one.
There's things also that I'm very unlikely.
Not that I didn't want to. It's just like,
Have you told him?
Yeah.
would spot that.
Is it the same in yours?
Yeah, it's so far.
Okay, so it might just be this one button that's off. We just do it that way.
Obviously, that's intended to be.
So we'll keep this one.
I've got Kingdom.
Okay.
I've got my own. I've got my own. Thank you very much. James, have you just got a few minutes?
Yeah, that's time is.
Yeah. Just want to do it from his own.
I'm sitting on. No, that's fine.
So this is the conclusion, then. Rounds 2 and 8. Round 1 is the section 1 where the definition. Section 1 terms. What is known. What is actually the substance? Is it applications it's about these arrests. It's not actually about the premises.
No, it's absolutely
Refuse permission. Subject to deposits. Bottom of the page where he just sets out the
I know it's individualised opportunities for explanation, but there's literally
that's the post dates. I'm just going to the inquiry. Basically, rest of the ground is the challenge to whether it should be consulted. That's a reason to have.
Thank you very much, my lady.
Not at all, any time, Mr. Thane, just indicate. Yes.
We've covered most of the points already. I just wanted to make one final point in relation to the proscription versus deproscription distinction. And just to note that the central ground of challenge which remains, effectively, after Mr Justice Chamberlain's judgment, is the human rights challenge, perhaps unsurprisingly. And almost all, if not the entirety of that, is devoted to issues and evidence from the other files that relate to events that happen after proscription anyway and depend upon the impact of proscription. So most of that evidence is after the event anyway, but the convention challenge is perfectly contented to be mounted to the continuation of this organisation in Schedule 2. I wanted to finish with one short point, which I've touched on already, which is that many of the points that are relied upon by the judge and that are relied upon by the other side are indeed general points, and they flow from the structure and the very detailed processes that Parliament itself has chosen to set up and the way in which it's chosen to do that. And the questions that prompt are, well, is it really legitimate faithfully applying the Glencore principles to turn back features of the regime on themselves, as it were, to say, well, that always justifies JR because the regime provides for the Secretary of State to have to make a deprescription decision. It prompts a broader question, which again sounds back into Glencore, about why it is, on the claimant's case, that the regime is not, to a very substantial degree, undermined if the force of those points is, as the judge held them to assert. Why would the claimant not always go for a judicial review of the proscription decision at that moment? And one of the impacts that would have, if that applies in a large run of cases, which on the logic of it could do and would do, one of the consequences that would happen is that you would, to focus back on the criminal side of things, never get to the point where the statutory mandatory quashing of convictions actually arose, because you wouldn't have got to that deprescription decision. because the JR would simply apply.
So I'm not following that. I mean, say you did go for JR and they were successful, then, and the quash order was granted, the order would be quashed and it would never have taken any legal effect. So the conviction would have to fall.
Well, then there would be a question that the criminal courts would have to determine about whether or not that is the effect of it, or that would be the effect of it. It's not entirely clear that that would be the effect of it. That's the answer to it. But my point is a broader one, which is that if you're going to turn the features of the regime back in on itself, it risks undermining it.
But one line of thinking would be that actually the regime is all to do with, essentially, with a change of circumstance situation, either way. So either there wouldn't be a JR of the original decision, or there would be a JR for which permission was refused, or a JR for which permission was granted but failed. So allowing JR in the what you might say is a standard sort of situation, where there's a change of circumstance post-prescription, doesn't turn anything on its head, does it? It means it's working in the way it should. You have JR of the original prescription decision, successful or not, but if it's unsuccessful, perhaps no challenge at all, then matters change one way or the other, and then there is a challenge or an application to deproscribe in the light of that change of circumstance. It all works perfectly then, doesn't it?
Well, it doesn't, because you cut out by doing that the requirement that Parliament has considered appropriate for the first port of call to be back to the Secretary of State. Your first port of call is always, on that conception of it, a JR. Now, of course, you can say you can have a JR of the original prescription decision, and depending on how you get on with that, presumably it would only be if the claimant has lost. They get a second bite of the cherry, and they get another go. They can then say, well, I'll go off and I'll invite a deprescription, I'll invite the Secretary of State to deprescribe.
It's not a second bite at the cherry if it's a change of circumstance case. It's a fresh application.
Well, it may or may not be. I don't know whether that's how it would work. It's query whether that's how it would work. Would you have to put material change of circumstance in front of your application to the Secretary of State in that situation?
But do you agree that a change of circumstance scenario does fit with a regime of JR for original challenge to decision to prescribe, but then after a statutory procedure for challenging or for refusal to deprescribe?
My lady, my respectful submission is that doesn't fit. It's not the way in which legislation is to set it up. It could have set it up in that way with a material circumstance test, and it has deliberately not done that. And if you do it in the way that my lady suggests, everyone's going to have a crack at the original prescription decision. Why wouldn't you? And then you have to ask the question, by reference to what do we then restrict the right of an individual who's been unsuccessful in the judicial review, by definition, unsuccessful in the judicial review, by what mechanism do we restrict? I mean, you may be able to design an abuse jurisdiction,
Yes.
something,
Yes.
but query whether you could do that. There is a statutory right to apply to the Secretary of State. And it would be at least open to question whether that would work. But my more fundamental objection to the way in which my lady puts it, of course I recognise that one could have a thing set up in that way, but that would be substantially to undermine the statutory regime, I submit. Because the reference back to and the requirement that the Secretary of State consider deproscription in the light of whatever it is that the organisation or anyone else wishes him or her to consider.
Ground 6, for which permission is granted, is based on a failure to consult, is that right?
It's ground 8.
Ground 8 even, sorry, forgive me. Ground 8.
Sorry.
In this case, it is being said that there was a failure to consult affected interested parties.
The slight problem I've got, I've got lots of problems, but if you look at the wording of the Act, I know it's old-fashioned, but if you actually look at the wording of the Act, even Section 4, it doesn't provide for an application saying the original decision was wrong, and it doesn't say you must apply for deprescription. It says an application may be made. It's hard to see for an order removing or changing the name. It's hard to see the fact that you can make an application to remove, that you may make an application for that, was intended by Parliament to be a necessary precursor to challenging the prescription decision
My lord, it's never
itself.
going to be set up in legislative language that imposes a requirement to do that, because the organisation may not wish to challenge. This is the conferral of a right to challenge. But if you're going to challenge, this is the route. That's why the may is in there, not a must, because it's the conferring of a right.
But maybe made removing an organisation, i.e., why doesn't it deal with? Why doesn't it say expressly? And if you want to challenge a prescription decision, then absent special circumstances, you do it by way first of going to the Secretary of State and then POAC.
Well, my lord, because my answer to that is because it doesn't need to, because the legislative draftsman, as you know, drafts on the basis that he or she is to be taken to have understood the surrounding case law, and the surrounding case law exemplified in Glencore indicates that this is not an ousting provision and is not intended to be an ousting provision, but the principles that apply are that this is a remedy because it's statutory and detailed and prescriptive. This is a remedy of first resort.
If you go to section 3, if you just look at it, section 3, 3.3, there are 3 things it said. Add an organisation, remove, amend. 4 then says an order under 3.3 or 8 removing or providing for a name to cease to be treated. So that again is looking just at part of the things that there. It doesn't specifically say anything about the prescription order. And when you look at the words of section 5, for example, subsection 5, where an order is made in respect of an appeal against a refusal to deprescribe an organisation, it's all expressed in terms of apply to deprescribe and then an order to deprescribe. And you're saying, but implicitly, because you could use the same sorts of grounds for deprescribing as saying the original decision was wrong, it carries with it the implication that normally the general run of cases is you shouldn't do what you would appear to be able to do JR. In the normal run of cases, don't JR, don't use the remedy that's not excluded, do this other thing instead.
My lord, yes.
And that's your case, really,
I
isn't it?
I say that because reading the legislation fairly and as a whole, it is evident that Parliament has decided that if you're going to challenge your proscription, the mechanism for doing that is to go to the Secretary of State first and then to use a specialist tribunal with all the specialist powers that it has. It is not ousting JR, but it is not ousting JR knowing that the case law on alternative remedy is set up as it is, in the sense that since Preston, all those years ago, the highest court in the land has been saying, you take account of the statutory remedy if it's available, and that is the remedy of first resort. So it doesn't need to do any of the things that my lord is identifying.
And I think early on in our exchanges, you said it was a question of collapsing. That would be to collapse form over substance. The way you put it.
That's what we're saying.
Yeah. Do we need to worry about the original wording? Because some of the words, for example, in 5.5, in respect of an appeal against refusal to deprescribe, have been added by the 2006 Act. I haven't looked at the original 2000 Act.
Okay, what my learned friend says, I don't think we have a specific point of interest on those new words.
Right, let's move on.
Yeah.
Let's move on. Yeah. Thank you.
Those are my submissions.
Well, Sir James, thank you very much indeed, as ever. Mr Blundell, Mr Watson, anybody following, nobody allowed to speak from the second row. Not today. Well, thank you all very much indeed. Yes, Mr Hussain.
My lady, my lords, I want to address you, if I may please, on the following topics. Firstly, whether the judge below diluted the test, and I will also address you on an important issue, the role of the court in assessing the adequacy of a statutory remedy. The second topic are the judge's 5 factors we say didn't err in respect of any of them. The third topic is KWP, I'll be short on that. And the last topic is our respondent's notice, which focuses on the remedial defects in POAC in light of the remedy that we have claimed. The court is, if I may say so, alive to all of them except 2, which I'll outline, but they are basically that Section 7 only bites does not bite on POAC allowing an appeal. It only bites if a deproscription order is made, and that then raises the concerns raised by my Lord Justice Edis. The second extra point, just very briefly, is related to that, is that in order to make, for POAC to make an order, what you have under section 5.4, what you have to have is outcome irrationality or no evidence. So our two grounds would not get us an order. So there are very significant...
Sorry, outcome irrationality or...
No evidence at all. And that is, in the Aramugam case, the LTTE case, it's Mrs. Justice Elizabeth Lang, as she then was. Paragraphs 20 to 21. I'll show you that in a minute. So those are two extra points about remedial defects, and of course that's very important to any issue of adequacy. So one, did the judge dilute the test? Not at all. What is the test? We say it's a two-stage test, and it is as follows. One, is the statutory remedy adequate to secure the rule of law? If not, then the court will not decline judicial review. Two, even if it is adequate, are there nevertheless exceptional circumstances that justify permitting judicial review? And the examples given are clear case of illegality. I think my Lord Justice Edis had in mind Lord Justice Sales, as he then was, in Glencore.
Yes.
The reference is para 55, page 477, and indeed Sir James below accepted that. See the judge at paragraph 32.
I think there's a passage in paragraph 54 and another one in paragraph 58.
Yes.
Same effect.
Indeed, indeed, indeed.
Whereby Lord Justice Sales is not saying that the alternative remedy principle operates invariably as a bar to any judicial review being given permission.
Indeed.
He's saying it may operate
Your point about
at the substantive hearing.
Indeed, indeed, indeed. Other examples where you could have an exceptional case, even though the statutory remedy is adequate, are where there is a need for an authoritative judgment. That's obvious. It's an example given by one of the commentators, Mr. Oburn et al. The reference there is tab 48, page 1320. So that's the test for which we contend. We thought it was common ground. It appears not, because Sir James's case now is based on inapposite authority for reasons I'll show you, and a fundamental misapprehension about what the rule of law requires. His case now is that in all contexts across the board, you presume the statutory remedy to be adequate. And that's why he says the judge below diluted the test. We say absolutely not. There are three fundamental reasons of principle why the court needs to consider adequacy for itself, respecting but not deferring to that which Parliament has provided, and certainly not operating a presumptive rule of adequacy. Of course, unless the context drives that or there is expressed language to that effect, the position is different. But at the level of generality, that is not the position. It certainly isn't the position here. The three reasons are: one, the question when an alternative remedy is raised is, as Lord Justice Sales put it in Glencore, whether the alternative remedy is effective and convenient to, quote, ensure that the rule of law is respected. That's Glencore 55. And in respecting legislative policy, I'm quoting, judges should only go so far as is consistent with the rule of law. That's Lord Phillips in the Supreme Court in Cart. at 82. I'll come back to CART. You haven't got it. It was cited in Sir James's skeleton, but it wasn't produced. It's a very important authority. So that's the question is, it's a rule of law question. What does a rule of law require?
Well, it requires a remedy. Question here is, who gives it? The
but-
rule of law is not going to be broken here.
No.
Subject to Section 7, because there will be a court body that will give a ruling.
No, my lord. I'm making the first of 3 points, saying that the test is, the question you're asking is the alternative remedy adequate to secure the rule of law? Step 1. Step 2, constitutionally, it is the court. It is the court, not Parliament, that is the guardian of the rule of law. Judicial review, of course, is a constitutional protection. And
It's
nothing...
a shared responsibility, but anyway. Right. Not Parliament that is guardian
Okay,
of
well,
the rule of law.
but we say, if you look at the court's approach to ouster clauses, and clearly that is what is going on. The court is regarding judicial review as a constitutional protection, and as Lord Dyson said, nothing is more basic to our system. He said that in the CART case as well. I'll show you in a minute. But the third reason is that institutionally, it is the court and not Parliament that has expertise as to what is adequate, especially when it is seized of the facts of the case and can, for example, see the remedial request in the case. And that is really important because the issue isn't an issue in the abstract, but it's an issue of whether the alternative remedy secures the rule of law in the particular circumstances of the case. As the judge said at paragraph 32, and as Sir James accepted, it's in the circumstances of the case. Now, obviously, we accept the statutory language, and exceptionally the context, may point to a need for greater judicial deference to what Parliament has provided. And the judge cited the sanctions context. The Samler legislation, the Sanction and Money Laundering Act, that you have that. I can take it up if you'd like, but the quicker way of doing it is simply to invite you to look at paragraph 30D of the judge below, and there he talks about two sections of Samler, sections 38 and 39. We say that provides very strong analogical support for what our position is, because Samler is redolent of our position in that Parliament drew a distinction between a decision to designate individuals for sanction and decisions not to refuse. And decisions to refuse to de-designate. You've got a similar structure, but critically, you've got a shall not be questioned clause, and we say that is a very clear indication that in that context, Parliament intended the statutory remedy to occupy the field. We would quibble, if we may, with the judge below saying that that's an ouster. It's not. Shall not be questioned. There's never been an ouster. Cheltenham Commissioners going back 19th century. It's not an ouster. But it's a very strong indication that Parliament intended the statutory remedy to occupy the field. And for that reason, we say we don't accept that the question of purported ouster, obviously complete ouster is completely different, that purported ouster is simply a gateway and is then irrelevant because in Samler, the court would have jurisdiction, we would submit as a matter of constitutional theory and in a proper case, but the court would be very slow to exercise it. And as the judge said at paragraph 30D, this sets the context. It's not simply a gateway. We have, of course, nothing like that. And therefore, the Secretary of State's claims in her skeleton and essentially before you today that Parliament intended that POAC should occupy the field, constitute a complete code, and that by providing for no appeal, this is her skeleton at paragraph 22, providing for no appeal at all against decisions to proscribe, Parliament intended to, quote, ensure the effectiveness of prescription decisions based on national security grounds by enabling such decisions to take effect before the right of appeal arises. We say that is really an extravagant claim. Parliament didn't intend to create an Alsatia around the decisions to prescribe. If I may be forgiven, amidst the clash of arms, the laws are not silent, mutatis mutandis. Only an effective ouster clause could achieve such a striking result. It simply isn't compatible with the rule of law. That is the question for the court to leave unchecked, ex hypothesi, an unlawful exercise of executive power to prescribe a fortiori, where here it has dramatic consequences for hundreds, thousands of people. We'll come back to that in a moment. So, going back to the authorities, please, if I may. So before I go to Watchtower, our two-stage test was the test which the judge was invited to apply by Sir James. It's a test the judge applied. It was common ground below, and we see that. Please no need to take it up, but just for your reference, we see that in the judgment below at 17 to 29 for a summary of Sir James's submissions, where he says that POAC was convenient and effective, paragraph 20. He sought to justify that case, saying it was adequate at paragraph 23 to ensure the rule of law. And then the judge concluded at 68 that it wasn't an adequate remedy. So Watchtower, please, if I can take you to that, that's at tab 25. And the reason this is important is not only for the way Lord Dyson set out the test, but also the way he applied it. There's nothing approaching, even though we're looking at a statutory appeal, and I entirely agree with what my Lord Justice Lewis said, and the observation of my lady, the Chief Justice, that this is important, but because it's about a statutory right of appeal, and that the dicta which suggest the single test, a presumptive adequacy, are dicta which concern rights of appeal, but they do that in certain contexts. Here, if Sir James is right, what Lord Dyson would have done is said, well, you've got a right of appeal before the FTT, that's presumptively adequate, you haven't got an exceptional case. He didn't do that, he didn't say that. And we see this, we look at, can I just start with the head note, please? There were two decisions that were, this is on page 450, if you have that. There were two decisions in play, judicial review of a decision to initiate an inquiry by the Charity Commission and a decision to issue a production order. The appeal was to the first tier, where the FTT was to apply judicial review principles, and therefore it was adequate with regard to the first decision, but not with regard to the second one because of the absence of remedial power, or, in Lord Justice McComb's view, a lack of clarity as regards a remedial power. So doubt points in favour of judicial review. And my lady, my lords, can I just take you, so the judgment begins at a couple of pages in, and if I can just take you to paragraph 20. So this is Lord Dyson applying the general principles he's just set out. And
I wonder whether it isn't better to look at statutory provisions.
Yes.
Because it is ultimately a question of statutory interpretation. To confer the power,
yes.
Paragraph 15, 31944 says, in determining such an appeal,
yes,
the tribunal A must consider afresh the decision,
yes,
director order, and then 320 provides that section 31948 does not apply in relation to appeal in relation to documents under 52. So that was the question there, is whether you could use JR in circumstances where an appeal wasn't available.
Yeah, and they said you could, but there was nothing about that presumptively being adequate. What I'm trying to say is that the court in that case conduct a freestanding inquiry about whether this is in fact adequate. And there's nothing about exceptionality when you look at the second bit of the case about the production order. They don't say it's an exceptional case because there's a remedy. They just say it's not an adequate remedy by reason of the lack of remedial provision.
It's not a remedy, full stop.
Indeed. Indeed. Well, I think we'd say that here. I did say that below.
But that's what the issue is. I think Sir James says it's implicitly the remedy, and you say it's not.
Well, it's not I say, he says. It's, well, what are the principles you apply? One principle that you don't... His case for why the judge below diluted the test is that he didn't apply presumption, essentially. It comes down to that. We effectively submit. Because he doesn't want to say he didn't give enough weight because he's in an appellate forum. So he wants to say there's an error of principle. The error of principle is no presumptive adequacy. And then he relies on tax cases to say, well, you've got to have presumptive adequacy. Well, that's not the position across the board. It's not the position here. And it's not the position in Watchtower. And it's even more importantly, it's not the position in Supreme Court, where you've got appeals. I'll come on to that in a minute. But very quickly, because I'm sure you've read ahead, my lords, paragraph 20 to 25, especially 24, the issue on the first aspect of the case turned on the submission rejected by the court that the FDT would not give proper reasons for its decision. Mr Clayton King's counsel, with respect to him running an ambitious case, which both the judge below and the Court of Appeal rejected, and the court holds that FDT was effective and convenient by analysing how the remedy would play out on the facts of the case. It didn't reason, as I've said, I'm sorry I'm repeating, claimant had failed to show exceptional case, or that the FDT route was presumptively effective and convenient. And then when it comes to the second decision, we see at 38, I think I showed you, that there again, Lord Dyson looks at the statutory provision, construes it against Mr Steele for the Charity Commission. Again, no deference. Well, Parliament intended that was right. It's a freestanding approach to construction, and he finds it's not adequate. He says the fact that over the 38, letter B, the fact that this narrows the appellate boundaries is neither here nor there. It doesn't mean it's a dead letter. We would make the same observation in our case. And then Lord Justice McComb, this is important because in some areas, Sir James said, well, it's not clear that a caution would run as it normally does, as in Miller, the prorogation paper wasn't presented. You don't have to decide that now. It's enough for me to say that it certainly isn't the case that POAC would give a proper remedy because of Section 7, and it looks like judicial review is capable of doing. It would be Mr James having a burden to persuade the court that it wouldn't. The point about doubt is, as I've said before, it runs in favour of entertaining judicial review if there is doubt about the efficacy of the alternative remedy. And we see that in Lord Justice McComb's judgment, paragraph 50. So that's Watchtower. Then, can I please take you to Cart? So I'm afraid this is an authority that didn't find its way into the bundle. It is very important we respectfully submit. Mr Luckhurst is going to just hand it up. We can arrange for electronic copies if you'd like them as well.
Please. Thank you. So this is...
This is Cart in the Supreme Court. And the reason... Sir James cites it in his skeleton at paragraph 24, but it wasn't in the authorities. The reason why this is important is because the court explains the judicial role when a statutory remedy is raised as a discretionary bar to judicial review. It's also important because it explains it siva subramanium. In fact, it departs from it on an issue that's not material to the debate here. And that's obviously the case on which Sir James relies. We say out of context.
Which paragraph would you like us to look at?
Can I firstly take you, please?
Paragraph 89, is it? Thereabouts.
Just before I get to it, 89 is the key one.
Yeah.
Absolutely. My lady's taken my breath away. That is the key paragraph. And you're there. It should be for the judges to decide. Letter D, it should be for the judges to decide whether the statutory provisions for the administration of justice adequately protect the rule of law, and by judicial review to supplement these, should that be necessary. Exercising the power of JR, the judges must pay due regard to the fact, even where the administration of justice is a state resources limited, no duplication of the judicial process cannot be justified by the demands of the rule of law. But also earlier...
But it does say, where statute provides a structure
yes.
to which a superior court or tribunal reviews decisions of an inferior court or tribunal, common law judicial review should be restricted. So that's what Sir James, I think, is saying. He's saying that properly read, sections 3 and 4 together form the code for, as he would put it, challenging the continuation of prescription. And where that is the case, there needs to be some reason for departing from that structure. I think that's what his case is.
No, we can get to the result in two ways. We can either say that, as the judge did, the first question is you look at whether the alternative remedy is adequate. And if it's not, you entertain JR. Or you can say, well, you've got to find a reason why it's not adequate. And you start from a presumption that it is. And what I'm trying to say is that in order to make good his submission that the judge diluted the test, Sir James has to pin his colours to the second way of looking at it. And there is not support for that. There isn't support for that in paragraph 19 in Watchtower. In Watchtower, paragraph 19, general principles, Lord Dyson sets out a two-stage approach. The other thing I wanted to show you in Cart was 82 earlier, where again Lord Phillips is summarising the G case, and he indicates there that the courts in that case, again, in the context of a statutory appellate procedure, statutory review procedure, considered that the statutory regime provided adequate and proportionate protection, and cites the court with approval between F and G. The key is G. Satisfactory operation and separation of powers requires that Parliament should leave the judges free to perform their role of maintaining the rule of law, but also that in performing that role, the judges, and then this is the key subordinate clause, so far as consistent with the rule of law, have regard to that legislative policy. And then if it's helpful, Lady Hale and Lord Phillips gave the majority judgments. If you want the references, I can give them to you, why that's the case. It's Lord Hope at paragraph 96, he agrees with both. Lord Brown at 97 agrees with both, and Lord Dyson. Lord Clark at 102, he says it's a matter for the courts to determine what the scrutiny should be. And Lord Dyson at 134 agrees with Lady Hale, Lord Phillips, and Lord Hope in the Scottish case. And I just invite you to look at 122 of Lord Dyson. He says any restrictions call for justification. So he puts it the other way around. Prima facie JR should be available to challenge the legality of decisions of public bodies. No principle more basic to our system of law that the maintenance of the rule of law itself and the constitutional protection afforded by judicial review. But the scope of JR should be no more as well as no less than is proportional and necessary for the maintaining of the rule of law.
Would that be a convenient moment?
Indeed.
I know I'm afraid I have some commitments
Of course.
that I can't avoid, but we're ready to start at 2.
Thank you.
Is that all right? Yeah. Thank you all very much indeed. 2 o'clock.
Thank you very much.